Ever made a deal, shaken hands on it, or signed on the dotted line, only to find out that you and the other person were both totally wrong about what you were even agreeing to? Well, today we're going to dive into that exact idea, the fascinating legal concept of shared mistakes in contracts. And we're going to do it by looking at two foundational cases that, believe it or not, still shape our world today. So let's kick things off with a modern-day puzzle. Just imagine, you find your absolute dream car online. It's a rare classic, the price is perfect, you sign the digital contract, you wire the money, you are thrilled. But then you get a call. And it turns out, unknown to you and the seller, the car was in a garage that burned down the night before. It's just gone. So is that contract still valid? Do you still have to pay? This is exactly the kind of thorny problem we're getting into. You know, the legal idea at the heart of our little car story is called a shared mistake. And it's pretty much what it sounds like. It's when both people in a deal are operating under the same huge false assumption about something totally essential to that deal. Now, this isn't about one person tricking the other. It's about a mutual, fundamental screw-up that can make a contract just poof, disappear, as if it never even happened. And we're going to see exactly how this works with two incredible true stories from the 1800s. All right, our first stop is way back in 1852 with a case that honestly sounds more like a maritime mystery than a legal dispute. It's all about a deal for a shipload of corn that was sailing from Greece to London. A simple transaction, right? Or so it seemed. So the setup here looks super simple. On one side, you've got Hasty, who's the seller's agent. On the other, you've got Couturier, the buyer. The deal couldn't be more straightforward. They're making a contract for a specific shipload of corn that's on its way from the Mediterranean. At this point, everyone thinks they know exactly what's being bought and sold. Simple. But of course, this is where things get interesting. While all the papers are being signed back in London, that ship is out on the open ocean. Both Couturier and Hasty are working under the assumption that the corn is safe and sound in the cargo hold, making its way to them. But what if that core belief, the very foundation of their agreement, was completely and totally wrong? And here it is, the big reveal. The corn had actually started to go bad during the long journey, so the ship's captain, seeing no other choice, had already docked at a port along the way and sold the whole lot. So, think about that. At the exact moment the contract was being signed in London, the thing they were agreeing to buy and sell, well, for the purposes of this deal, it didn't even exist anymore. They were literally buying a ghost cargo. This wild case gave us a vital legal principle with a fancy Latin name, res extincta, and it literally means the thing has ceased to exist. The court's ruling was simple. The contract was void. Why? Because you just can't have a valid agreement to sell something that isn't actually there. It's a huge protection against these impossible contracts. But what happens when the thing does exist, but the mistake is about something else entirely? So, if you thought a non-existent cargo was a bit strange, our second story from 1867 is, frankly, even weirder. This one's about a man named Cooper who wanted to lease a salmon fishery from another man named Phibbs. It was a beautiful, productive fishery that he knew really well. And again, the initial setup seems totally normal. Phibbs appears to be the owner of the fishery, and Cooper agrees to pay him to lease it for a while. A standard lease agreement gets drawn up, everything seems completely routine. Nothing to see here. And here comes the twist. You just can't make up. It's the kind of thing you'd expect to see in a movie. Both men were acting in good faith. They both believed Phibbs had the right to lease out this property. But what if the guy paying for the lease, Cooper, was actually the rightful owner the entire time? And yep, that is exactly what happened. After they made the deal, it came out that because of a super tangled and misunderstood family will, Cooper had actually inherited that fishery. He was literally paying money to rent his own property. Both he and Phibbs were completely, fundamentally mistaken about who the real owner was. And this case perfectly illustrates our second big principle, res sua. It means the thing was already his. It's simple. You cannot make a valid contract to buy or lease something that you already own. Just like with our ghost cargo, the law says this kind of shared mistake about ownership makes the contract void right from the start. Okay, so we've got a ghost cargo and a guy unknowingly renting his own property. Two totally different stories from over 150 years ago, but they both lead to the exact same outcome, and their legacy is incredibly important for all of us today. So let's connect the dots. So let's break this down side by side. With res extincta, the ghost cargo, the thing you're making a deal for simply doesn't exist.
Think of it like buying a concert ticket for a show that's already been canceled. Then you have res sua, the unknowing owner, where you're trying to buy something you already own. That's kind of like accidentally setting up payments to rent your own storage unit. In both of these weird situations, the shared mistake is so deep, so fundamental, that the contract just can't survive.
So why do we still talk about spoiled corn and a mixed-up fishery from the 1800s? Because these ideas are the absolute bedrock of fairness in contracts. They protect all of us from being legally trapped by impossible promises. It doesn't matter if you're buying a house, a piece of software, or a car. These rules make sure that if the very subject of the deal is fundamentally misunderstood by both sides, the law gives you a way out. So really, the big takeaway is this. A contract is meant to be a meeting of minds about a real thing. And if that thing turns out not to exist, or if it already belongs to the person trying to buy it, well then there was never a real meeting of the minds to begin with. The law gets that, and it recognizes that even with the best intentions in the world, a contract built on such a huge, shared mistake is basically just an empty promise. And that leaves us with a really fascinating thought to chew on. These principles were born from deals about physical things, corn and land. But today, we deal in digital assets, NFTs, and complex financial instruments that can be created, copied, or deleted in an instant. What does res extincta, a ghost cargo, look like in the metaverse? What kind of bizarre res sua situations are going to pop up with blockchain and digital ownership? It seems the tale of these two mistakes is far from over.